Hello, my name is Tania Voon. I'm a professor at Melbourne Law School, the University of Melbourne, Australia. I'd like to acknowledge the traditional owners of the land where I live and work, the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past, present and emerging. Today I'd like to speak briefly about the growing use of foreign investment screening, which has been intensifying in recent years, even before COVID. And by this I mean requiring government approval for a foreign investment to be made in a country where that investment is above a certain value threshold or in a particular sector. Several countries have introduced foreign investment screening where it did not previously exist in those countries, or they have been expanding the lists of strategic sectors that are subject to screening. Other countries have been introducing a retrospective element to such regimes, whereby, for example, an investment that was made lawfully in a country 5 or 10 years ago may be subject to screening and further review on national security grounds, with the potential for a requirement of divestment. Now, when countries are introducing these policies or expanding or modifying them, they need to make sure that they're complying with their obligations under international investment agreements, particularly bilateral investment treaties and preferential trade agreements with investment chapters. According to UNCTAD, there are around 2,500 of these kinds of agreements in force, and most of these agreements have a mechanism for ISDS, investor state dispute settlement, whereby an investor, a foreign investor, may bring an arbitral claim against the state that is hosting its investment on the grounds that that state has breached its treaty obligations. And if successful, that could mean an award against the host state in the order of millions or billions of dollars. Now, when subjecting an existing investment to screening, for example, because it is seeking to expand or subject to a retrospective mechanism, this may be more of a problem under international investment law because it means that concerns could be raised even under treaties and even with respect to obligations that do not cover the pre-establishment phase of an investment, such as expropriation and fair and equitable treatment. Now, some countries do ensure policy space for their foreign investment policy, including screening, in their investment agreements, and this could be done, for example, explicitly. So some countries, some treaties exclude foreign investment policy from ISDS, or they may list foreign investment policy as a non-conforming measure with respect to certain obligations, such as non-discrimination and performance requirements. Now, general reforms to international investment agreements can also lend some protection to foreign investment screening. For example, where there are clarifications to investment obligations or the use of general exceptions and security exceptions with respect to investment obligations. Now, these kinds of legal issues do need to be considered by countries that are introducing or modifying their foreign investment screening regimes, and also by countries that are drafting or revising their international investment agreements. So I'll be looking at these and related issues over the next few years, subject to an interdisciplinary discovery project that is funded by the Australian Research Council. So do look out for my work along with my colleagues, Professor Andrew Walter, who's in International Relations at the University of Melbourne, Professor Philip McCalman in Economics at the University of Melbourne, and finally Dr. Laura Puzzello in Economics at the Monash University. Thank you.